around. The sky was blue without visible trailing, and it was a pleasant day. I'm so looking forward to having this opportunity for a discussion with you and with our guest today, who will be none other than Jim Turner of Swankin and Turner, a Washington, D.C. law firm very well known for its involvement in health freedom causes, and Jim is also president of the Citizens for Health.
You know, I want to talk about the blue sky for a moment because, as you know, and as our listeners may or may not know, I am in Santiago de Chile. When I first came to Santiago just a little bit over 2 years ago, there was no chemtrail spraying, no geoengineering that I could detect. And then about a year ago, things began to change, and the amount of chemtrail spraying, the amount of greasy, dirty, gray sky that would then be hit with pulsations, frequency pulsations, and drive the clouds into very, very peculiar formations, some of them actually even rectangles across the sky. That increased and increased. For the last 2 days, the skies have been blue when I woke up. That hasn't happened for a very long time. And I don't see the filthy, dirty skies that I had been seeing regularly on a daily basis for many months. How about you?
Well, it varies. You know, we're up at about 900 feet elevation, which for the East Coast is not bad. And we're about 50 miles west of Manhattan, almost due west, a little bit north. So we've noticed that a lot of the chemtrailing activity is, as I put it, off the mountain, down below Sussex County, New Jersey, where I live, and more into the areas of Morris and Essex and Bergen County, 3 counties that used to be among the highest income counties in the country before, of course, all the income in the country was concentrated in the counties around Washington, D.C. over the past decade or so.
Uh-huh. So that's very interesting. Let us hope, if it's not too much to hope for, that this shows that they've recognized the total failure, the abysmal failure, which Dane Wigington and others have been documenting, of this vile program. But we have more things besides chemtrailing to talk about today. In about 6 minutes, our guest, Jim Turner, who is a longtime freedom advocate and a man that both you and I admire greatly, he'll be joining us. Meanwhile, let's talk about the health freedom news. What's happening on the health freedom front? Let's talk about Ebola.
Is there anything else to talk about besides Ebola?
Well, there's ISIS.
There's ISIS, right. ISIS, Ebola, ISIS. The president of our foundation, General Bert Stubblebine, he was Army retired, wrote an article a few weeks ago entitled just that, ISIS, Ebola, in which he was observing the way the mass media was being used to link these two truly terrifying topics together. And he was speculating. We always speculate. Here on the Dr. Rima Truth Reports, we are about truth, but you can't reach truth if you're not willing to speculate on what is true and false. And we certainly do so here. I think that we need to keep an eye on skies and an eye around us. Well, what's been happening on Ebola? Dr. Rima, the media keeps on telling us, oh, it's sloughing off, it's going down. Nothing to see here, folks. Go away. Is that really what's going on?
No, it's not what's going on. Apparently, we have Ebola patients all around the United States based on the best information that I have available. And that those Ebola patients are hidden. They are diagnosed with malaria incorrectly. They are diagnosed with typhoid or typhus. They are diagnosed with anything else except Ebola. And according to medical personnel, they and their records are then being disappeared when they are discovered to actually have Ebola. Now, the diagnosis of Ebola is a sometime thing. The Problem is that the most advanced...
Africa, where this horrid situation is most further developed, then it's not that easy to tell the difference between Ebola and dengue and West Nile and any one of a number of other diseases that might be wafting through the port cities.
Well, it's not that easy to tell the difference at the beginning. At the beginning, there is a kind of generality of illness. You have headache, you have malaise, you feel miserable, you feel weak. But then when you start vomiting, projectile vomiting, when you start having unstoppable and especially bloody diarrhea, when you reach the third stage of the disease and you start bleeding from your eyes and your ears and your mouth and your nose and your skin and your anus and your urethra and any other orifice that you happen to have around, then it's pretty easy to tell that you've got a hemorrhagic virus. You still can't tell whether it's Lassa fever or Marburg virus or Ebola virus, but you can certainly tell that you've got a hemorrhagic virus, and in the contagion situation, that is assumed to be Ebola at this point.
And I guess it doesn't matter at that point, does it? If you're in that state, you're experiencing essentially complete runaway scurvy, the destruction of all the vitamin C stores in your body, and the collapse of cell membrane integrity.
Yes, actually, we don't have very much vitamin C storage capacity, but when vitamin C is not replenished because we can't make our own through the food that you eat or the nutrients that are given to you, then that's true. And you also have what's called a cytokine storm. But it doesn't matter in this way. If you have Marburg, which is killing people in Uganda at the moment, I have no doubt that it's weaponized Marburg virus, by the way. If you have Takarib, if you have Lassa fever, if you have Ebola, if you have any one of the hemorrhagic viruses, and you have been fortunate enough to not be stopped by WHO, FDA, and CDC from getting the nutrient that your body needs, nanosilver, 10 parts per million, your body will have been able to repel the invader. It's like a ship at sea. When the pirates come on board, if your soldiers have the capacity to repel the invaders, then your ship sails on and you didn't get burned and you didn't get plundered and you didn't get sunk in the sea. But if your soldiers and your sailors, and by the way, Marines were special soldiers who were kept on board ships to repel the enemy, to repel pirates. So if you have enough Marines and if your sailors are well enough trained, if your immune system is honed and sharpened and supported by, for instance, nanosilver, 10 parts per million, then the virus can't adhere to your cells, the virus can't puncture your cells, and the virus can't therefore inject its DNA and take over the DNA capacity of your cells to manufacture itself, little copies of itself, and then disperse them by bursting the cell. So it's a matter of having your Marines and your soldiers and your sailors all in good enough shape, and that comes through the proper nutrients. And it's no surprise that the nutrient that's most critical here is a mineral, because as Linus Pauling and others of his generation, including Abram Hoffer, said, there is no disease which is not a mineral-related problem. So if you can supply the mineral, in this case nutrient nanosilver, 10 parts per million, that you need, then the pirates don't get to come on board and take over your vessel. You. Hello? Are we there?
Are you with us?
I am.
And to bring our guest on for you.
Well, before you do that, let me tell people where they can get the nanosilver. It's very important because Ebola's around, and I believe it will get worse, and if it doesn't, the next plague is on its way, for sure. So you can go to, write this down, http:// donate.dr Rima truth.com. Donate.drrimatruth.com, because there is no other nutrient that has been shown to be effective in supporting the immune system specifically against Ebola, and your government does not want you to know that. We do want you to know it. Now I'm delighted to talk to our guest. For those of you who don't know much about the Natural Solutions Foundation, let me take a moment to introduce you to us and to ourselves. We did this a little bit on our first show last week, but briefly, I am a physician. I have practiced drug-free natural medicine and psychiatry for 44 years. That means I have never written a prescription for treatment. I once wrote a prescription to wean a patient off a dangerous psychoactive drug, but that's the only drug prescription I've ever written. Why? Because drugs... Well, I'm so pleased. Let me finish my sentence and then we'll welcome the estimable Jim Turner. Hold on one second. I was saying that drugs are not necessary except in the surgery suite or the emergency room, and we focus on your right to use natural options, if you so choose, for your health, and the freedom principles that are required for that to be real. Okay, now our guest, the experienced and always insightful Jim Turner. Hello, Jim.
Hear me introduce. Hi, Rima. Hi, Ralph. I said the Washington insider lawyer, and I heard the hisses from the audience.
Yes, and booze. Yes. Oh, you Washington insider lawyer, you.
Magnificent legal thinker, and actually a really decent human being. Jim, welcome. Even though you haven't retired yet, you should stand among the angels.
I'm not retired, and I'm not planning to be any angels.
Let me tell the audience a little bit about our history with you, Jim. The first time I met Jim Turner was at an Expo West meeting. I had been calling Jim for many weeks, and his office never returned my call. And I walked up to this man that I had never seen, but who had been pointed out to me. And I said, "Are you Jim Turner?" He said, "Yes, I am." I said, "Well, my name is Rima Laibow, MD, and why haven't you ever returned my calls?" And he said, why were you calling me? And I started talking to him about it. And we started talking about Codex Alimentarius and the dietary supplements suppression that it was engaging in. And we started talking, and he said, "Look, why don't you come to Washington, D.C.?" I was living north of New York City at that time. "And we'll talk for 24 hours. Because we have some differences here, and that would be useful." I said, "You got it." And I drove to Washington, D.C., and we talked for 24 hours, and we became intellectually respectful and intellectually bonded about the issues. And then sometime later, is that right, Jim?
So far.
Yeah. Then, sometime later, I drove to see Ralph, who was at that time still Mr. Fucetola to me, and I said, "Look, Codex Alimentarius has to be solved at the legal level, and I want you to do it." And he said, "Okay, but I'd like to bring in one of the best legal minds I know." And I said, "Well, who's that? Is it somebody we can trust?" He said, "Jim Turner." I said, "You got it." So we called Jim, or Ralph called Jim and said, "Hey, listen, this is very, very interesting. We need to work on this." And Jim said, "You got it." And these two gentlemen, Ralph Fucetola, JD, and Jim Turner, are you a JD? Is that your degree?
I know.
You are. Jim Turner, JD, spent uncounted hours pro bono finding the solution for the planet to Codex Alimentarius. That's who they are. That's what they do. And I'm so honored to be in their company.
It is such a wonderful opportunity. We don't have enough time just to chat, and it's a nice chance to chat before an audience. We sort of feel we know the Micro Effect station's audience because we've so often been on Larry's and Kraft's program and other programs. So it's just a great opportunity, and I'm really happy to be here as well.
Well, I'm happy to be here too. We didn't lose Rima, did we?
No, Rima's here. She's happy too. There's something going on. There's something going on right now that most people listening to us don't know about, and it affects every aspect of their health freedom. It affects whether or not they get to hear about cancer cures, or those cures are sequestered and suppressed. It affects whether or not they get to make health choices based on truthful information. It affects whether or not research can be shared to help them in their health freedom choices. It affects whether, in fact, you and I have the right to say what we believe, or whether the U.S. government can compel us to lie for the financial benefit of its friends. Gentlemen, this is a profoundly legal issue, and I wonder if you would talk about it from your specialized knowledge perspective, but use a few simple words so I can follow.
And why don't you define or name the issue that you're talking about?
Okay, the issue is that nanosilver, let's start back in 1994. Ralph, you want to give our listeners a background on DSHEA?
The sad part about it is we have to go back even before, way before 1994. We have to go back, I guess, Jim, we have to go back maybe to 1911 or maybe to 1903, because there's some famous cases involving vaccines. Let it be said that for over 100 years, as the federal government blossomed into the institution we all know and love so well, that along the way, there were some landmark cases about the power and scope of that government's bureaucracy. And interestingly enough, as one looks at those cases, one begins to understand that in the decades following to the cases, the bureaucracy sort of reinterpreted the case to support the power when there were actually cases about limiting the power of the new bureaucracy. And coming forward to the 1930s, that occurs again when the FDA receives a major dose of power, and it occurs again in the early 2000s. So 1994 was DSHEA, the Dietary Supplement Health and Education Act, and then coming into the early 2000s with the so-called Food Safety Modernization Act, a series of laws that increased the FDA's power, step by step by step. Power, and of course, when you remember what Ron Paul said about that, giving the FDA more power, he said, is giving them more power to abuse. And that's gone on step by step for well over a century, 110 years and more. And we've seen the issue be faced that now, by some people's count, up to 780,000 Americans a year die from FDA-approved and properly prescribed medical treatments. And so, Dr. Rima, when the FDA says there's no approved treatment for Ebola, people should sigh with relief. Approved treatments seem to lead to death in many, many cases.
That's a very good point.
The issue we're faced is, of course, as suggested, right there in 94, as the Dietary Supplement Health and Education Act. I remember when it was being debated in Congress, showing up at a lobbying day. We had a rally on one side of Capitol Hill, and we went into the office building, and that was our Congress people. My son, who's now 26, was about, I guess, 5. He came with us. He got his first taste of Washington. And we knew we were supporting a flawed law. We may not have known exactly how flawed it was, but we knew we were, and we knew we had to do something to stop the raids. Because the big news of the mid-90s was that if you said anything about food and health, you were likely to see your health food store raided.
Indeed. Jim is the one who told me, who shared with me the information, that it was at that time illegal to use the word food and health in the same sentence or on the same sign, as in health food store.
Right.
Right, Jim?
That's probably fair. I think Jim will be, when he gives us his response to this little bit of history. But I think that what we worked on in the years following the share, the cases that Jim has been involved in, that we've had a chance to interact with him on, has shown us over and over again that the legal position of the federal agencies is precarious, that they will do whatever they can to prevent courts from actually making decisions and giving redress to grievances, because when the courts get a hold of these things, they very often restrict the agencies and empower the people. And that's what we're going to be seeking again. We've been given an opportunity by our friends in the federal government of testing the limits of their power. We received a warning letter back in September 23rd telling us that we really can't tell people about a certain government study that was declassified. When we say declassifying, it means we can talk about it. And the government interpreted that study in a way that made our nano-silver 10 parts per million a so-called drug, unapproved drug. Well, these issues are going to be tested, and I'm sure that Jim has much insight into them. But what happened in '94 was that Congress both gave us something, the ability to talk about health and food, and took something away from us. And they took something away from us by trying to censor what we could say about health and food. And I believe that that era of censorship is coming to a crashing end. And I think that it's coming to an end because of Supreme Court decisions that are not only from 1903 and 1911, but also from 2002. And I think that if the issue gets into the courts, and that's where the federal government has developed great skills at avoiding allowing its citizens to have their day in court and redress a grievance. But if it gets to the appeals court, I believe that we're going to have a lot more freedom of speech about health than we have had for several generations. Is that so, Jim?
Well, I mean, we certainly have a pathway to make that happen, but I learned long ago, don't ever predict what a court's going to do.
Yep.
When you're in court, it's a roll of the dice. We don't have very much sense of where appeals courts will go. In fact, if you come into D.C., there's you're likely to win or lose on the basis of who the three-judge panel is that you get selected by randomly. One set will be very strongly pro the FDA, and another set will be very strongly anti the FDA. Or you could get two of one and one of the other on a panel, and end up with a 2-to-1 decision. Whichever decision is made by the appeals court, I'm certain will be appealed to the Supreme Court, and often the Supreme Court will take cases from this circuit. And we'll see. There is a path. There is a path, and there is an argument for why what the FDA is doing with regard to your specific case, the nano-silver situation that you got a warning letter on, and a broad range of things that the agency is doing. It's a fundamental premise, both the FDA and the FTC, and I would argue all the other 50 or so regulatory agencies, their fundamental premise is to take some patina of authority that they've gotten by the legislature and then just begin systematically expanding their application of it and daring someone to oppose them. And then what happens is usually they're daring some commercial interest, and most commercial interests are more interested in their commercial activities than they are in any kind of fundamental principles. So what they tend to do is come up with an agreement. I mean, as far as the manufacturers of most foods and drugs, it doesn't matter to them all that much what they're selling, as long as they've got a little piece of paper from the FDA that says it's okay. You can make these claims, you can do this stuff, and so on. As long as they've got that little piece of paper from the FDA, they feel comfortable to go out and make money. They don't feel a strong compunction about fighting any kind of bureaucracy creep. You do that for 10 or 15 years, and then pretty soon the FDA is arguing precedent. They're saying, well, we've been doing this for 10 or 15 years. No one else ever complained. Why is this person complaining?
Haven't the courts along the way overturned censorship rules that were as old as 75 years. I'm thinking, of course, of the compounding pharmacy case.
Well, the FDA has managed to make a number of interesting political errors in coming into the judicial world. The Supreme Court ruled very early. Food and Drug Act was passed in 1938. Actually, that was the current act. It repealed the 1905 Act and set in place the new act. And almost immediately, the FDA started to restrict dietary supplements. They considered them to be, for whatever reason, right from the get-go, they thought they were bad things, and they went after them. And they tried to eliminate them starting in 1941, and they did get a very strong Supreme Court case about not being able to enrich farina. It was a case against Quaker Oats. And so Quaker Oats was in a position where they could no longer actually enhance the value of their cereal by putting
I do believe that we are coming up on a break, Jim. We'll have about 5 minutes and we'll be back.
You can take a break and I'll pick right up there.
All right. And with our guest, Jim Turner. Both of these gentlemen are freedom-fighting attorneys, and we're talking about the FDA's attack on nutrients, on supplements, and on truth. Because one of the things that I want to emphasize that our listeners need to understand is that this warning letter that we've received about nanosilver and slightly about CBDs, but primarily about nanosilver, which we say we have good evidence to believe supports the immune system in such a way that when confronted with the Ebola virus, it can handle the attack. And we have both laboratory evidence and now we have clinical experience from Sierra Leone. In the law that was passed in 1994, we are forced to say that we are forced to refrain from saying that a nutrient can be associated with the words cure, diagnose, treat, or prevent any disease or condition. We can't say that about a nutrient, even if we know it to be true or believe it to be true. And the FDA added the word mitigate. So we are forced to make disclaimers, and we are forced to say things that we don't believe. And at the heart of this matter, at one level, is the issue of whether or not the government can compel a lie instead of compelling you to only speak truthfully. Jim, would you pick up where you left off?
Well, I was saying that the FDA made an interesting strategic error in the early 1940s when they went after supplements, nutrients added to food, and got a ruling from the Supreme Court saying that they were allowed to write a standard that excluded in this instance, fortifying farina with various nutrients. By the way, that led to the very interesting situation that you could not even market something called fortified farina. That was not permitted. But what they established was that their authority rested on writing a standard, a food standard, and they then tried to go after dietary supplements as entities, starting in 1941, actually. And the court systematically rejected them all the way up through the 60s. And they basically created a situation in which the FDA was forced to try to create a standard for dietary supplements, which they began doing in 1962. And they had a long hearing. It went on for a decade, trying to come up with, and they did come up with and propose a very strong compendium for dietary supplements, and they made that proposal and announced it. And many parties, there are actually 11 altogether, including my representation of a consumer group, opposing the FDA determination. And that case was heard before Judge Friendly in New York. It was a very interesting situation. He's one of the finest judges we've ever had on the federal bench, and in fact is the reported mentor of Chief Justice Roberts. And I remember that hearing very well because at one point, Judge Friendly said the FDA counsel. So let me try to actually, of course, the Justice Department. Let me ask you this question: are you saying that you believe vitamin C should be restricted to 120, I think it's 120 milligrams per day? They said yes. He said, well, that's funny. My wife gives me 500. That was an interesting. Sort of an interesting flag wave of an indication of how he's going to rule, but ultimately it turned out he threw out the entire rules, and that was the end of the FDA trying to write a standard for dietary supplements. That case was decided in 74. 76, Senator Proxmire and Congressman Rogers passed a bill known as the Proxmire Act, which which clarified FDA's authority over dietary supplements, which are under the Special Dietary Food section of the Food Division of the Food and Drug Act. In fact, it's very, very important for us to remember that dietary supplements are a food. They are the most highly regulated food we have. The notion that people push on them, that they are underregulated and they should be pushed into the drug category is fallacious and incorrect. It's scientifically unsound, legally improper, and morally damaging.
Right.
It's a bad idea. In any case, the courts have upheld that, and Congress upheld that with DeShay. The DeShay law is an amendment to the food section of the dietary supplement of the Food and Drug Act, and dietary supplements remain a special category of food. And the notion that they should be measured against food standards is like ridiculous. Okay, so anyway, that's the framework. And because the FDA worked itself into the position of having to enforce its bias really against dietary supplements by writing a food standard, the law systematically over the years from 1941 until 1994 systematically carved out a space for special dietary foods known as nutrients, and so it's vitamins, minerals, herbs, and things that go into making up vitamins, minerals, and herbs. Amino acids are in there as well. That category then was put into legislation with DeShay. A lot of the repressions of the Food and Drug Law were carried forward. It's very important to understand that the statements that you made, Rima, about nano silver and other products of that kind not being allowed to say cure, treat, mitigate, prevent, or diagnose, you can't use any of those 5 words, applies to all foods. Not just dietary supplements, but to all foods. Once you say those things, then you have created by the FDA's analysis, a drug, and then therefore you need to be subjected to all of the rules that have to do with drug testing. We had a case before the FTC on some dietary supplements, and we were talking about an herb. I've actually forgotten what it was. But in any case, it had at least 50 and maybe 500 different single ingredients, and the FTC, it was expert witness, said it would cost $100 million to test one ingredient. $100 million, and this had at least 5 and maybe 50 different ingredients in it, single chemical entities. And the argument the FTC was making was that it should be tested the same way a drug is tested. The fallacy in that argument is that the reason drugs are tested the way they are, and the reason the rules are written the way they are, is because drugs are, by definition, an inherently unsafe set of chemicals. And the argument that's made is, given that they are inherently unsafe, they need to demonstrate that they have benefits that outweigh their lack of safety in order for them to be used. That's the argument. They're inherently unsafe. That's the need.
So
what you're saying is that it's an exercise of the government's police power, and that's only invoked when there's some public harm, and that comes from the inherently unsafe nature of the substance, similar to perhaps the arguments on tobacco.
That's correct. And the key point in DeShay is that the DeShay recognized that nutrients are in fact inherently safe, And therefore, they said that if there is an instance in which there's something unsafe about a nutrient, it's the FDA's responsibility to come forward and say, look, the way this is being used, or the formulations and the way that it's being done is unsafe, and therefore you have to apply these kind of rules. That's the structure of the Food and Drug Law. Things on the food side are considered to be inherently safe. Things on the drug side are considered to be inherently unsafe.
And logical. I mean, there's a logic to the fact that foods have been with us for literally thousands and hundreds of thousands of years. And by now we know the difference between poisonous foods and safe foods.
Well, they then slipped into this peculiarity of saying that anything that claims to cure something, and those other four words, anything that claims these things, we will treat as if they are inherently unsafe by virtue of the fact that they made that claim. Well, the argument they make for the inherently unsafe nature of claiming that something will, let's just use the word cure as the stand-in for all five words, to claim that something will cure something is inherently unsafe because it will cause somebody to not use the inherently dangerous thing that they've determined is safe enough to be allowed to be overridden by the benefits. And so the result is that you are herded almost automatically, and I always, my own view is it's not a conspiracy. I always say that if you have a choice between conspiracy and stupidity, always choose stupidity. And this is a stupid set of arguments. It makes no sense to argue that claiming that, let's just say you did claim it, you didn't, but just suppose you did claim that nanosilver would cure Ebola. Suppose you claim that. How does that turn nanosilver into an inherently dangerous product? It doesn't. You can argue that the claim should not be made because you haven't demonstrated that it will. Perhaps you might want to do that, but that's not the way the FDA goes about things.
But
the idea is that
didn't the FDA go one step further, or I should say Congress? Because remember, FDA, FTC, these are creatures of Congress, and only go as far as Congress allows, or as you pointed out, as far as they can grab, based on whatever Congress allows. But didn't Congress go a step further in 1994? When they compelled speech, there's not one bottle of vitamins in this country that is sold without compelled speech. That's English two-sentence disclosure, which I'd like to repeat to the audience, and that is the following words. These statements have not been evaluated by the Food and Drug Administration, period. Not intended to cure, well, the five words. That compelled speech, to me, is inherently violative of the First Amendment, and it's a way step beyond saying you can't make these claims. Now it's saying not only can't you make those claims, but you are compelled to express the opinion that your product does not do what it may very well in fact do.
Well, that certainly is going to be the test of the courts as we go forward. It's a very interesting technical problem because the FDA there is the argument that comes from doing bad things, which says that in the law you must intend to do bad things if you actually are going to be held accountable for doing bad things. If you do bad things accidentally, that's a different set of laws than the laws that say you are not permitted you are violating the law if you intend to do something that's wrong. If you do something accidentally, that's a civil problem that you have to go get sued for, and it's a tort, and then you have to pay money and so on.
That's proven intent. That's double expressed intent.
Well, don't mix up your compelled and your intent here. The fact of the matter is, you intend this to be whatever you intend it to be, and they're trying to tell you that you don't intend it to be these things. They're saying you can't work at it. That's right, and that is what will be tested. Now I can tell you, we've come up against this with the FTC, and they have been willing to alter the letter that you send out. Because by the way, the compelled speech just begins with that particular statement, because one of the things that they do is force you to send a letter to all of your customers saying you didn't intend this. Now, so some people have refused to sign that letter. It's an interesting dynamic because they're in a logical pickle because they cannot tell you what you intend. And so if they're telling you that you intend this to be something in particular, you are being forced to say something you may not agree with. On the other hand, it's a pickle from your side too, because you don't want to go around saying you do intend this stuff if it's going to create a huge battle with the FDA. So what we need is the court to clarify what's allowed here, and we think we're pretty strongly of the opinion, you and I and the people on our side, that the government cannot force you to say these things. And we have some precedent for that, and I think that some of the things that Congress has put in the books and that the FDA has continually to expand the meaning of have never been tested in court, and it's going to be a very, very interesting problem for the court to take a behavior of the FDA that's been around, let's say, 50 years, which we believe is unconstitutional, and we don't believe Congress ever intended.
There's a wonderful video on YouTube where I interviewed Ron Paul about raw milk. This is when he was still a member of Congress. And as part of that discussion, we talked about the Interstate Commerce Clause and restrictions on the agencies. And in that discussion, he was very clear in his understanding that what's going on is that our First Amendment rights are being violated. And to me, it seems, Jim, that the Interstate Commerce Clause, which is part of the original Constitution, has to be read as subject to the First Amendment, not vice versa.
Well, I would certainly think that you're absolutely right in terms of legal theory and legal application. You may not be right in terms of what the courts believe. And remember, the law, whatever it may have been when it was written, turns out in practice to be what the courts believe it is. And over the years, the Interstate Commerce Commission, the Interstate Commerce Clause, has been one of those things that the agencies have used to constantly encroach. I mean, look, it's unconscionable what's going on in raw milk. It's just indefensible and unconscionable. That poses no problem of any kind that anyone can demonstrate, and people want it. They're actually making contracts with farmers to produce it, and the agency is stepping in and trying to stop them. It's legal in 20 states. What is this? The FDA takes the position that as a federal agency, they can override 20 states' laws. That's the way they're behaving. It's just another one of those encroachment things. But let me make a point about the raw milk thing, which I think is something that's being overlooked in general. That raw milk campaign was launched as a part of the stimulus program. So there was money available to get grants to go out and do stuff, and various enforcement agencies, and it looks like there's a team that's both made up of state and federal investigators on raw milk that are working across the country, and it appears that they're funded by stimulus money. Well, interestingly enough, the expansion of the vaccine program has been funded by stimulus money, as has the placing of smart meters across the country, which is causing another batch of problems. As has this wild campaign going on, arguing that high fructose corn syrup is the same as sugar. I mean, it's just another one of the fraudulent things that government says, and then they get paid by the government to run around and say it. So New York City tried to get the law passed, court stopped that, based on the notion that high fructose corn syrup and sugar were the same. Los Angeles, Hawaii, several other places have tried to take actions that lump all so-called sugars, they made up the name sugars, for about 15 items, when like 95% of the diets of the non-diet sodas in the country are high fructose corn syrup. All of these programs, all sugars are the same program, the smart meter program, the vaccine expansion program, and the raw milk program are all stimulus money programs that were generated by grants given by the CDC and other government agencies to use up the part of the $900 billion that was adopted to turn the economy around. Now, no one oversaw that activity. No one had looked at to say this is a good idea. These bureaucrats just got in there, got their hands on money, and then started running around funding people, state governments, nonprofit groups, and so on, to put out and then pay for things like vaccinations, and put out just false information right across the society.
Yeah, but why? Why did they choose this false information? Why weren't they putting out information like, aspirin causes internal bleeding and it doesn't do a thing for your cardiovascular status campaign, for example?
All these programs that I identified, were on-the-shelf programs that had been designed in the past and had been pulled off and not pursued. For example, on the smart meter program, the utilities had pulled the smart meters because they considered the smart meters to be not a valuable asset to the grid. They then went ahead and when they said we want shovel-ready projects, that was the term, shovel-ready projects, they pulled this smart meter program, which was basically an outdated technology, and put it up there. And they got $1 billion from the government, and they matched that with $1 billion of their own. And that $1 billion of their own goes into the rate base, and it creates the opportunity to raise energy fees. The same is true with the vaccines. This huge, massive expansion of the vaccine program over the last 5 to 8 years is a direct result of the fact that Merck needed to be bailed out because of its Vioxx losses. So, the vaccine program is the Merck Savior program.
America's, the largest free enterprise is really crony manipulation of not just taxpayers' money, but borrowed money.
Well, on the high fructose corn syrup situation, that's just the corn industry. Corn is a huge, huge, huge lobby. I mean, it's 10 times larger than sugar. It's out there constantly grabbing and gorging on money from the government. They've got huge amounts of money on this ethanol program, which is a disaster across the board. They've got, high fructose corn syrup is about 5% of the corn industry's money, but they fight for that like they're like chickens scratching for seeds in the ground, man. Every single thing they can find is $1 from the government they want, and they go after it like crazy. So if they can get the government to run a national program saying, high fructose corn syrup and sugar are all the same, and confuse the public and cause people to feel bad. There's a movie out that says that kids can't eat candy anymore because of the battle on sugar. Well, it's a battle on high fructose corn syrup. There's a lot of candy around that doesn't have high fructose corn syrup in it. You could eat good candy if you wanted to, in moderation. But they've created it now as if it's a poison. High fructose corn syrup is a poison, and they just want to say every sugar's like that because they know people aren't going to give up sugar. That was all paid for by the government. The American government is a enabler of corporate activity. And you ask why do they support these things and not things like the aspirin problem? Well, because the aspirin problem isn't going to make anybody any money. So there's nobody out there pushing for it. There's nobody out there to say watch out on how much aspirin you take. I mean, you can find the whole aspirin story if you work hard and dig hard for it. It's a tough story. Aspirin's a tough problem.
And we are coming to the end of the second segment. We will be back. Our guest, Jim Turner, here on the Dr. Rima Truth Reports. My co-host, Ralph Fucetola, and I'm Rima E. Laibow, MD. We'll be right back. Welcome back to the Dr. Rima Truth Reports. I'm Rima E. Laibow, MD. I am the Medical Director of the Natural Solutions Foundation, www.drimatruthreports.com. When you visit that website and enter your email address, I will give you 2 gifts. The first is a protocol on how to use nanosilver to support your immune system, because after Ebola comes the next plague, and after that comes the next one. These are weaponized, genetically engineered atrocities. And nanosilver will support your immune system no matter what the name of the assault. with me, my co-host, Ralph Fucetola, and with us, our guest, who is most knowledgeable, as I'm sure you're hearing, and that gentleman, Jim Turner, is part of our legal team for saying to the FDA, which I refer to as the Fraud and Death Administration. I suspect that our papers to the federal court will not identify it that way, but saying to them, as we say here in the Spanish-speaking world of Santiago de Chile, where I live, basta, enough, enough suppression, enough repression, enough illogic, enough unfair and insane policies to keep us from speaking truth and sharing truth. Jim, you were saying.
Before we go back to Jim, Dr. Rima, I want to just say one or two quickies. One of them is, first of all, to thank Jim for sharing his vast knowledge and experience with us. When I jokingly referred to him as a Washington insider lawyer, I was only half joking. He's been there. He's been in that city for decades. And he knows, as he's told us, as he's rattled off the facts as he knows them, it's been extraordinary. And I want to also say to our supporters out there, people who are in private association with Natural Solutions Foundation, we're seeking funds to support the litigation that is going to happen. We want to afford as much of Jim's time as we can possibly do, and we need your help to do that. There's a website you can go to in order to do that. You can go directly to the donate webpage, and I'm going to give it to you right now. So please pick up a pencil, take a private note, and join us. It's http:// but no triple W. So it's http:// donate.Dr. Rima Truth. That's DRRIMA, 2 R's in a row, Dr. Rima Truth.com. That's a different webpage from our general website, which is drrimatruthreports.com.
Now, one of the things you'll find when you go there is that you can make a selection of nano-silver products. We have not only the nano-silver 10 parts per million liquid, but we have a wonderful gel, which is a hand sanitizer. We have, and it's also wonderful for wounds and lesions on the skin. We have hand wipes impregnated with nano-silver and lozenges with organic flavors and glycerin and nano-silver. So that's a wonderful way to support your immune system and provide yourself with some useful help. I'm sorry, go ahead.
Yes, apropos to Jim's discussion, we note that those nano-silver gel products that the FDA and the EPA have both approved nano-silver products as a hard surface sanitizer and also for wound dressing. So this strange dance that Jim has been describing for us of how these laws came about, it all fits into the way real people are engaged in real commerce, fulfilling consumer desires and needs.
I want to interject something here. When I first met Jim and I walked up to him at the meeting in Anaheim and introduced myself, I left out a piece of the story. I said to him, "You're wrong about Codex Alimentarius." And he said, "What do you mean?" And I said, "Well, blah, blah, blah." And he said, "No, yeah. And so we talked about it a little bit. And that's why he invited me to come to Washington so we could talk for all that time. One of the important pieces here, Jim said, given the choice between conspiracy and stupidity, he'll always choose stupidity. And I have to also add in the effects of fluoride, which makes people apathetic and dumb. And an apathetic, dumb bureaucrat is a fearsome thing. But or an additionally apathetic and dumb bureaucrat can be really scary. But there is a conspiracy going on here in Liberia, where the Natural Solutions Foundation donated enough nanosilver, 10 parts per million, to conduct a clinical demonstration which was approved by the government. The doctor in the isolation ward in Monrovia was unscrewing the cap of the first bottle to pour the first serving for the Ebola patient, and the phone rang, and it was the number 2 person in the Ministry of Health of Liberia who said, and I quote, WHO will not permit the use of nanosilver in the clinical demonstration. The clinical demonstration will stop immediately. In Sierra Leone, where the president of the country set himself in direct opposition to the WHO, which told him and his cabinet members, quote, you may not use nanosilver against Ebola. WHO will not permit it. President Koroma threw the chief of station out of his country, creating an international incident. And then, with great difficulty, we got a limited number of nanosilver bottles to Sierra Leone. The results were spectacular, and WHO, which holds the purse strings and controls all the doctors and nurses, has forbidden Sierra Leone to purchase nanosilver for their people. I would call that, given the fact that on August 12th, WHO said that it was now ethical and legal to experiment with anything without informed consent and use anything that had even the faintest possibility of helping in the Ebola situation. And here we have something that's safe and has research behind it, and yet they say no. For me, I find it inevitable to rely simply on stupidity here, and I'm afraid that I must resort to conspiracy to make sure that nanosilver is not used and that Ebola is not stopped. Jim, what do you think?
Well, I think that I stick with stupidity. I certainly can't call that anything other than a stupid decision. But the reason stupidity is the important issue here is that if anyone else wants to say conspiracy, that's fine with me. They can say conspiracy. But if I go to court and I have to convince a judge it's a conspiracy, I have 10 times as much work to do than if I have to convince them of stupidity.
I'm sure of that, but I'm talking about the on-the-ground reality, not the burden of proof reality.
Well, just remember that the issues in a court are credibility issues, and the issues to your listening audience is also a credibility issue. And it's a lot harder for people to believe that there's a conspiracy than it is to believe that there's stupidity. Now, I'm not going to discourage anybody who wants to go to you or anyone else to say there's a conspiracy, and I am absolutely sure there are conspiracies that exist. But as far as I'm concerned, what I'm interested in is making sure that people in the world in general, U.S., Sierra Leone, wherever they are, have the right to make the choice for their own pathway to health. They have the right to choose whatever they want to choose, even if it means choosing something that it turns out wasn't the right thing to choose. They have that right, and the thing that needs to go along with that right is to be informed. And when anyone steps up and says, I'm not going to do X, they're acting in a way that is not wise when, if they're going to ban you from doing X, they're not wise unless they can meet an enormously high burden of proof, which in this instance I don't see that they have. And I would say that I can explain that to a judge or to a member of the public a lot more easily than I can say that there are a bunch of people sat around in a room and decided that nanosilver shouldn't be sold to the people in Sierra Leone, which it may or may not be true. What I do is I adopt the agnostic position. I don't know whether it's true or not. I hate to have to prove it.
Well, truth beyond a reasonable doubt for conspiracies.
That's right.
At least when they're criminal conspiracies.
Well, I certainly don't think you were saying this was anything other than a criminal conspiracy.
Well, I think genocide is sort of a crime, yeah. But be that as it may, the reality is that nanosilver is being kept out of Africa, and nanosilver is being information about nanosilver is being strongly attacked here, and we, the Natural Solutions Foundation, and our legal team, and I am proud to say that Jim Turner is part of our legal team, are in the process of defending not only your right to know about nanosilver, but your right to know about health-related matters in terms of nutrients, which are foods, and therefore foods in general. Let's say that bananas could cure diabetes. They can't, but let's say, for an example, that bananas were shown in a series of clinical trials to cure diabetes. You rub the banana in your hair twice a day, and your pancreas revives and starts making insulin, and your body uses it. Let's say. What would have to happen to make that information available freely and make bananas or banana extract or banana shampoo available without interference from the regulatory agencies, gentlemen?
So we're talking about not the ingesting of the food, but we're talking about putting it on the body.
Well, banana supplement. Let's stay with a banana supplement. Forget about the hair thing. I was being silly. Let's say a banana supplement.
What you'd have to prove, it's an easily said formula, and it is not on its face stupid. It is just stupid when you examine it at the second level. But what you would have to say is either the banana or an ingredient in the banana was consumed in a way that demonstrated that it affected the disease that you're talking about. And then that wouldn't be enough. You would have to say, and the mechanism of action for doing that is X, whatever it is. And so you have to show, you have to run a set of trials in animals to show that the banana stuff wouldn't hurt the animals. Then you would have to do another one, several, actually 2 clinical control studies in humans showing, A, that the substance itself affected the disease you named, and then B, you would have to come up with something that would show the mechanism of action. If you couldn't do that, then you could not put bananas on the market as something that would help with the disease, whatever it is. And on the face of it, that's not necessarily stupid, particularly if you're using something inherently dangerous like the chemicals that go into pharmaceuticals. I mean, these are inherently dangerous chemicals. Why would you ever put one in your body? Well, they come back with the argument. Here's all the really good things we showed in our testing. Now, there are all kinds of problems with that particular construct. But why would you say that about a banana? I mean, suppose, now the real fact of the matter is that there are things like turmeric, which is what I was thinking of earlier, which have been used for 1,000 years in India for all kinds of health purposes. The one ingredient in turmeric has had 11 clinical trials that have some suggestion that it might in fact cure cancer. But the argument of the FTC and the FDA is that you have to spend $100 billion per active ingredient, of which I said before there are between 5 and 50. There may be as many as 500. But you have to test each of those ingredients and the final product at $100 billion an entity to put the thing on the market. So who knows what it is in the banana that's going to cause all the good stuff. You're going to have to break the banana down into every one of its nutrient contents, every one of its non-nutrient contents, every one of the active ingredients in a banana, if there are any, and test every one of them. So you're talking about, $5 billion, $10 billion to say whether it will work or not. And this is blatantly crazy. And I suspect, and I think that if we could look at it carefully, I suspect that these kinds of requirements are one of the things that has run the American healthcare costs up to being twice that of the next most expensive country per capita. This structure is so pleasant to the pharmaceutical industry that they pay over 2/3 of the salaries of the drug regulation at the FDA through their payments that they have to make in order to get a drug approved. They have to pay for that. They love to pay for that. It's terrific. It's fantastic. because out the other end comes billion-dollar marketing products. But that's what you have to do with your banana, or there are lots of things closer than the banana that have valuable aspect, valuable health impacts that the FDA doesn't allow to be claimed.
Indeed, and I chose an extreme example for that reason, so that we could talk about it in the abstract. But you're right, turmeric.
I think Rima's talking as well.
Oh, sorry.
Go ahead, Ralph.
I was going to say that it seems to me, Jim, that in approaching this, treating foods as though they were drugs, we really are creating a situation in which a few companies can monopolize speech about health, because they are the only ones who can pay the toll to get permission to make those.
Well, there's a tricky problem in all of this, which I find quite interesting. The rules that we're talking about only apply to somebody who wants to sell the product. So if Dr. Rima did not want to sell the nano silver, that is, if someone else was selling the nano silver and Dr. Rima just put it on her radio program and said nano silver is really great, there's nothing the FDA could do about that. You could get on there and say anything you wanted about it, and in fact, you mentioned several times the year 1911, and there was a case in 1911, a Supreme Court case, which I consider to be one of the most important food and drug cases decided by the Supreme Court, in which Justice Oliver Wendell Holmes said the case was a situation where a manufacturer of a device, I believe it was a device, sent it to D.C. Saying it would cure cancer, and the Bureau of Chemistry, then the precursor of the FDA, and the Post Office and a couple of other agencies all got together and banned it and said you can't make the claim that it cures cancer. And ultimately that case made it to the Supreme Court, and Holmes overturned the lower decisions, or he overturned the regulators' decisions, arguing that basically whether or not something cures something is a matter of opinion. And the Congress only had the right to make laws that describe matters of fact. This will be one of the key points in the case that we're pursuing. They only can make laws that control matters of fact. And he said that things such as what's in the package, what the how much there's in the package, what it consists of, and so on, are all regulatable. But whether or not it cures something is not. Now, his ruling was that therefore Congress never intended to give FDA the authority to regulate whether something cured something or not. The Congress the next year passed a law explicitly saying that the FDA, or the Bureau of Chemistry at that time, did have the authority to regulate whether something did or did not cure, and you could making that claim, and then they set out a set of criteria which put the entire burden of proof on the FDA. That law has never been tested in court, and when the Food and Drug Act was passed in 1938, it repealed the 1905 Act and included authority in the 1938 Act to let the FDA require prior approval before marketing. That has never been actually tested in terms of claims for food. And all of this is stuff that's going to be part of this case going forward. And incidentally, on the raising money for the case, understand that there's a lot more to the case cost than merely our fees. And we're a relatively inexpensive law firm in Washington, but there's going to be experts, lots of experts. There's going to be a lot of time spent slugging through the trenches with the FDA, unless they drop the whole case. Don't forget that they could just drop everything, and you just go ahead about your merry way.
What are the other?
We did submit to the FDA, and they required in their letters a specific plan of compliance, which included, I think, 12 or 14 points. So, and I said in that letter that we sought to allay the concerns of the agencies. We're doing our best to be good citizens here, facing a federal bureaucracy which has grown increasingly less humble over the years. And Jim, there's one more thing we should talk about perhaps as we run down the end of the show, and that is the citizens petition
in a number of situations, I feel the citizens' petition is extremely valuable. We've not made a determination yet whether using it in this case makes sense or not. But in general, the principle that we rely on is that the FDA can't take action against somebody until they've reached a final administrative action. Ordinarily, that's used against individuals who want to complain about the FDA. They say, we can't complain about the FDA till it acts. Well, we've put petitions in for many subject matters that the FDA doesn't manage itself to get to for 2, 3, 5, 10, 15 years. In an instance where we are petitioning that a product have a standard written for it, and that we are complying with that standard while we market, and we've asked the FDA to recognize that standard, we are taking the position, and we believe that we have the court support for this. You never know when you're going to court, that the FDA cannot act against the products that we're talking about until they act on the petition. And we'll see what happens. It's very important to understand that this entire legal activity is a game. And Rima, one of the reasons why I don't like using the fraud argument or the conspiracy argument is that I think we're dealing with things like, just imagine a bomb. And what we're trying to do is dismantle this bomb wire by wire. And using the conspiracy argument and the fraud argument is like walking up to the bomb with a shovel and banging it over its head. And you bang and bang away on it, and the thing that's most likely to happen is it will explode. If you can get in and start dismantling it wire by wire, I think we have a better chance of getting the issue resolved without a whole lot of collateral damage. Now, I understand that there's a counter-argument that blowing the bomb up will get people's attention and we'll get more people involved and we'll have a bigger fight, and that's certainly a political strategy. It's not the one I choose because I think that there are some real opportunities to dismantle this bomb. On the other hand, it doesn't, for me, it doesn't make a whole lot of difference if other people went around and say it's a conspiracy. We're talking directly and specifically about specific legal opportunities that exist in the law, most of which, in my opinion, have not actually been tried up until now.
And of course, what Jim is talking about at one level is his special area of expertise. He's written on the transpartisan imperative, and he really is an expert on bridging the gaps between different positions. And so we're very excited to have his guidance as we move forward. We're advocates of a specific position. He is an advocate of the rights people have.
Of you to be advocates. That's a very nice point to make. I believe it's extremely important that your ideas, your views, the things that you're saying about nanosilver and all the other stuff you're saying, be out there and be protected and have the right to be said. And for the FDA to step in there and try to stop that, I believe harms me and all of the other consumers who are smart enough to make choices using your information and all the other information sources that they have. And the notion that the FDA is going to be the arbiter of what I am going to be able to choose at the market is not something that I find very comfortable.
I recall a meeting in February of 2008 that General Byrd and I attended. It was a meeting of the Codex Committee on Foods and Foods for Special Dietary Uses, Foods and Nutrients for Special Dietary Uses. And at that meeting, which was specifically about GMO labeling, the delegates sat around a great big table, and as an observer, I sat at the table too, getting glares from Barbara Schneemann, the FDA delegate, by the way, or the U.S. delegate who was from the FDA, I should say. And at one point, the European representative said, why does the U.S. prohibit the labeling of GMOs? We don't understand this. And Dr. Schneemann didn't answer, and then several other people took up the cry, and insisted that the United States delegate give a reason. And what she said was quite astonishing to me. Anyway, maybe it won't astonish other people, but it did astonish me. She said, the United States has determined that genetically modified foods are substantially equivalent, which, by the way, is a non-science bureaucratic finding. It makes no sense. The United States has determined that GMOs are substantially equivalent to unmodified food, and the public rejects GMOs. So because we, the FDA, have determined that they are substantially equivalent, which means there's no difference, it is up to us to prevent the public from making an error by rejecting GMO foods, which they would do if they were labeled, so we make sure that they don't know which foods are GMO so that they can't make that mistake.
Hey Jim, how does that sort of viewpoint comport to Supreme Court decisions such as Thompson versus Western States?
It's a tough question because the courts have listened to that issue and come out on the FDA side on several occasions. Or the FDA or local regulators. Monsanto's been very, very diligent in pushing very, very hard legal prohibitions on labeling GMO-free food. It's a tricky problem because what they do is they fight the requirement that it be labeled, and they've had a little less luck. They did for a little while have luck blocking the voluntary labeling, but that's been essentially solved. But they're blocking if farmers get drift of GMO seeds into their crops, they will sue the farmer for misappropriation of property, and they're winning those cases. We need to be very careful about the courts because they are not uniformly on our side or even neutral. They are subject to the same kind of political pressures that the rest of society is. Now, on this, it's substantially equivalent. One of the things I think is interesting is that I would suspect that Barbara Stamen has no idea how that decision got made or even what it means. All she knows is that in the job that she's in, those are the words she's supposed to say. It's kind of like snapping your fingers and getting a magic shield around you to protect you from any kind of attack. I mean, she just says substantially equivalent, and then everything's supposed to fall away, and she's supposed to be left alone.
Well, there was an interesting sequel to that. I take verbatim notes by typing, and my notes were then requested by the Norwegian and Swedish delegates because they didn't have their own recording, and they were found to be accurate. No one had any objection to them. But when I published a press release saying the United States delegate had explained why the U.S. refuses to allow labeling, Dr. Schneemann came up to me the next time I saw her, and she's in Washington, and she looked at me with tears in her eyes, and she said, "How could you publish that about me?" I said, "It wasn't about you, it was what you said." She said, "But I never said that." And I said, "Well, actually you did, and I quoted you verbatim." And she said, "Well, my feelings are hurt." And I said, "I'm so sorry, maybe you need to change your position or that of the government." And she glared at me. So you're right, she has no idea what she said. She's like a kid who gets up in second grade and recites a poem. "Oh, Captain, my Captain, the boy stood on the burning deck." You had no idea what people are saying. They just say it. So it was kind of like that. And we're coming up to our last break. Don't go away. We will be back. Jim Turner is our guest. Ralph Fucetola and I are here on the Dr. Rima Truth Reports on the Micro Effect.
Ladies and gentlemen of the class of '97,
Welcome back to the Dr. Rima Truth Reports. You're with us on our last segment today in our amazing opportunity to have two of my favorite lawyers talk about law and liberty and the FDA. You were saying, as we came to the beginning of this break, Jim, are you there?
What was I saying?
You were talking about
Well,
how.
let me go back. Let me say what I was, I think, starting to say, and,
Okay.
And we can go over that. The story that you told about Barbara Stamen is, I think, a crucial fact about what we're dealing with here. The vast majority of people who are in the bureaucracy and encroaching on the rights of the individual are essentially ignorant about what's actually the effect of what they're doing. I think that mainly they're not morally directed either in a good or bad way. They're there and they're just carrying out their work. I've known so many of these people. I've known them when they are in their job and when they're not in their job, and I can tell you that they are nice people. Many of them, I don't know all of them, but many of them are very nice people when you know them personally. But when you watch the way that they operate, you say to yourself, how could a nice person like that behave in that manner? There is a way that the bureaucratic essence captures the heart and soul of people who are otherwise perfectly fine people. And the thing just goes out grinding away, grinding, and it's amazing. It's just amazing to watch people get into these jobs and just shackle themselves. They're like the water buffalo on the wheel that goes around and around. They put on the harness and they put their hands on the bar, and then they just push away and they just grind and grind and grind.
You know,
the fact that people are dying and being maimed and being killed, and just take the vaccine world. The United States government has paid $3 billion to families whose children have been killed or maimed by vaccines. The United States government has paid $3 billion to families whose children have been killed or maimed by vaccines. These are products that are mandated by law. We know that children are going to die as a result of the mandate for vaccines. And the answer to solve that problem is to put a bunch of money, charge every vaccine dose that's sold, a piece of that goes into a fund at the federal government to pay families whose children will die from those vaccines. That is not a moral act. That is not a moral country. That is not a responsible way to behave. That's not why regulation was originally established. And yet these people are over there working away as water buffalo on the wheel, pushing, grinding out more and more opportunities for children to be mandated to take vaccines and then die. And it's a tiny number of children. Maybe a small amount of collateral damage, not like a huge epidemic, but every child has the right to be alive and survive. It's not that we should say one child should be sacrificed for every 100 or 1,000 or million that are saved. That's not the way we think about things. That's not our society. That's not what's right. And there are people out there now, I suppose, who are saying, well, wait a minute, one dead child for 1 million people saved, that could be, and they might want to go for that. I don't think that's correct, because I think it's very, very important to figure out how you create a society in which all the children are safe.
Absolutely.
Taking point. It seems to me also interesting to note that the last time I heard the figure about the vaccine injury compensation program, it was $2 billion. And so
that was 10 years ago. That was 10 years ago.
Yeah.
And that's quite extraordinary, especially when you consider how little that represents in terms of success of the parents, given how the deck is stacked against the families by the definitions, by the procedures, by the special court.
Well, most vaccine injuries never make their way into that program. The vast majority are never looked at as a harm. And then, of all of the ones that get into the program, only a tiny, minuscule number actually get compensated. It's a huge, huge, huge problem, and the culture is not anywhere near dealing with it. I mean, but that's only one of many such things, because we really, when we decided to solve our problems by regulation, and started in 1887 and with in 88, 89 when the Federal Interstate Commerce Commission was created. We subsequently, over the next 100 years or so, created another 50 to 100 of such agencies, and we abdicated our responsibility as a democratic society, turned it over to a technocratic society, and said these technocrats know better how to take care of us than we know how to take care of ourselves. And I think, Ralph, at the outset, you said, we're kind of in a state of taking back a lot of those rights. And I think that's exactly what's going on, and it's extremely important that that effort be successful.
Exactly, Jim. I think you pointed out exactly the way we need to understand it. We are in a time that is fraught with danger and with possibility. I'm personally, scared. I mean, I've got a warning letter from the FDA and the FTC. I've got to be concerned about that. But on the other hand, I'm very excited that it gives us the opportunity to assert our rights. It's only if we're willing to assert rights that they can be preserved. And to do that takes a certain degree of risk. And we have to be willing to take that risk if we're going to leave a better world for future generations. And so I'm hopeful, and I see great many things. If we look at human civilization in the long run, we have to say the past few hundred years have been centuries of great advancement. Just 300 or 400 years ago, a handful of powerful and bloody monopolies ruled the whole Western world. The great monopolies over land, called feudalism, the monopolies over commerce, called the king's monopoly, the monopoly over women, called the legal infirmities of women, and of course the monopoly over the very lives of some people, called chattel slavery. All of those institutions, which had existed for thousands of years, have been drastically done away with or revised in ways that have left such room for human capacity that we've grown a civilization to the state that it is today, where 6 billion of us can survive on this planet in more or less relative harmony without having had a thermonuclear annihilation yet. So I'm hopeful over the long run. I think that the insupportable burden of bureaucracy will turn out to be insupportable, and it will simply not be able to sustain itself.
Well,
that day is coming so rapidly, maybe even tomorrow.
Irony in what you say is that all of those things, let's just take, just human slavery, had bureaucracies that were enforcing them. And they counted and they assigned and they had legal responsibility, and there were agents that ran out after runaway slaves and so forth. And there were all kinds of people in that bureaucracy who were there just because that's the way things are, that's the way they've always been, and we ought to keep them that way. And an awful lot of the people who are in the bureaucracy running the regulatory structures of the country currently are operating in much the same way that the regulators of slavery operated when we had slavery.
Absolutely, and I want to make a point here. You talked about the people.
Ralph, Rima's talking again.
Oh, that's a bad thing.
It's your program.
No, it's our program. I wanted to make the point that these lovely people who are perfectly delightful and they're very pleasant to have dinner with or a conversation with, who act stupidly and harm people, I am unimpressed by the fact that somebody is a decent human being when it's totally private. The commandant of Auschwitz raised roses, loved dogs, and was very nice to children, of course, German children. But he was also presiding over an unmitigated and unthinkable evil, because he dropped a wall between his private goodness and his public lack thereof, or his occupational lack thereof. And so I'm unimpressed by people who are perfectly nice, but then they do something that they certainly wouldn't want done to their mother or sister or to them. And they have a special way of looking at the world that allows them to do whatever it is that they're supposed to be doing, whether it's right, wrong, or harmful. I just wanted to say that I'm unimpressed by the fact that somebody knows which knife and fork to use and can be pleasant. I've had many non-hostile encounters with Barbara Schneemann before I published her remarks, of course, and she was a charming, pleasant lady in the elevator of the hotel where we were both attending meetings. That's irrelevant. It's what you do that counts, is it not? Especially when what you do affects the lives of millions of people.
I remember that wonderful movie, Brazil, which sort of examines the type of society that we're becoming, in which some of the Monty Python crew create or dissect the nature of fascist societies. I don't know if either of you've seen that movie, but there's some scenes that remind me exactly of what you're talking about.
Well, they spent a lot of time making fun of that particular world, and the point here is not whether to be impressed or not impressed with these people. My point was very simple, and that is that you've got people in there who are operating in a negative way, having virtually no knowledge that that's what they're doing. I'm very clear that Hitler and his leadership were very clear about what they were doing, but there are an awful lot of people in the regulatory structure here in this country who don't have any idea what they're doing. They just sit there and routinely turn out this kind of stuff, and you have to understand that the rhetoric that's put out by them and for them to repeat is how wonderful what they're doing is for everyone. I mean, these are all wonderful, life-saving things that they're perpetrating. They aren't sitting around knowing that they're doing something bad. These are wonderful things that they believe everybody would embrace and would enjoy. Hitler, on the other hand, tried to hide what he was doing at the end of his life. I mean, he knew damn well that he was doing something that was not going to look good and stand up when under scrutiny.
Well, go ahead.
I think the fact that people do it out in the open does give an indication that they either believe that they are justified. I mean, well, actually, that's what it does. They are like the Grand Inquisitor, like the Grand Inquisitor. Dr. Rima, on the other hand, and this is interesting, Jim, the lawyers here, one active, one retired, and the psychiatrists are coming down on sort of different sides on this issue. What Dr. Rima is saying is they're psychopaths. And what we're saying is, well, I can understand...
No. I'm not saying that every bureaucrat who makes idiotic decisions and furthers the...
Again, Ralph.
I'm not
Go ahead.
I'm not saying that every bureaucrat is a psychopath. Psychopath is a much overused term. I'm saying that people who separate their areas of responsibility, being kind and compassionate, thoughtful and alert in one, and failing to be so in the other, are not, in my view, rendered non-culpable because they're nice at home. Or it's the same thing, somebody abuses their child at home, but then they're a great boss at work. It doesn't mean that you didn't abuse your child, and the impact is as it is.
Yeah, Rima, I think Ralph was onto something here. There's a different point here. The people who are nice at home that are running the bureaucracies in this country actually believe that they are being nice at work. They believe what they're doing is the right thing. They're not over there saying, "Well, I have to hide what I'm doing."
Precisely. They're just like pediatricians who actually like kids, most of them do, who are vaccinating them because the brainwashing has been so complete that they happen to have surrendered their rational powers in order to be part of a system that they believe is positive. So when a pediatrician wants to vaccinate your kid, as long as he also vaccinates his kid and is vaccinating himself, he's a deluded, useful idiot. When a pediatrician doesn't vaccinate his kid, or like William Ivey, the state prosecutor the state's attorney in Maryland, who admitted that while he was compelling the vaccination of 900 children under threat of imprisonment of their parents, he himself did not allow his own children to be vaccinated with the same vaccines because the risk was too great. Then we've gone from useful idiot to malignant idiot.
Well, I think it's really important to draw a distinction between those two kinds of issues, and that's kind of the point I'm making. Those are whatever the facts in those situations, those are two very, very different approaches, and I personally, both of them are serious problems, but I actually believe that the ones who are out there saying they're doing something that is good, who are doing something that isn't good, are a greater problem because there are more of them and they spread the word much farther. I'm saying our vaccine regulatory structure is so destroyed. I mean, it basically just does not exist. There's no regulation of the vaccines at all. And when I say regulations, what I mean is there's no system anywhere where anyone's looking seriously at the immediate and long-term risk and benefit ratio. And the result of that is children are dying because no one is taking their interest seriously. That is a serious problem, and I think it's more serious because of the people who believe they're doing the right thing than if I was just dealing with a bunch of nefarious crooks.
I agree with you.
Nasty people than it is to deal with people who are intending to do the right thing and then end up doing the wrong thing.
I agree with you. I think the well-meaning idiots, the useful idiots, are trustworthy because when they say, I believe this is good, you can tell they're telling the truth. Their whole energy field and communication system resonates with truth and sincerity. They just happen to have been misinformed, and they do great damage in that way. I agree with you. There are fewer psychopaths, there are fewer sociopaths than there are well-trained, healed, and controlled useful idiots.
As we reach the last couple of minutes of the program, we've reached some very deep, powerful issues that resonate to the question of whether American society, here at the beginning of the 21st century, has become pathological, in which a society in which the most those who want to get ahead gravitate to the center. Remember I said earlier, back 10, 15 years ago, the highest income counties in the United States were the very wealthy counties outside of the major metropolitan areas, like Morris County, New Jersey, and places like that. Today, the 10 wealthiest counties in the country are clustered right around the tip of power itself, Washington, D.C. We've seen a major change in the nature of American society going on. And my question to the good doctor and to counsel is, are we reaching, as it were, a breaking point when things must change because they will change?
Let me answer first. What I think is going on is that we're in an evolutionary process, and we have repeatedly over the years dumped the old code and put on a new code. Jefferson has a great quotation in the Jefferson Memorial, which says that the laws of society need to be changed as the human mind advances. Said I'd sooner wear I would not changing those laws is like wearing the coat of a boy when you're a man. The issue we're dealing with here is that the culture is maturing very, very rapidly, and what's happening is that the elite that's in control of the force, which is what the government is, it's controlled force, is trying to use that force to stop the evolution that's underway. And I don't think it's being very successful. I think that we've moved massively progressively since the Second World War in the kinds of directions that the country was originally intended to move toward. There are lots and lots of barriers that need to come down. I think most of them, or at least very, very many of them, are coming down as a part of that evolutionary dynamic. And my sense is that if we work really hard and push really hard on issues like this one that's come up for you guys, we are going to find that the system is a lot more porous and flexible than we suspect, looking at it when what we're facing is the phalanx of power that is used against the kinds of things we're interested in.
I agree with you. I think that you spoke about the, Ralph, about the the systems, and you, Jim, too, about the systems that have been used to control for a very long time. What we have is a breaking out of awareness and the counter movement by the forces that want to keep you right back in that mold. And so there really is a kind of movement and counter movement as the society wakes up, thanks to the internet largely. The society wakes up very rapidly, and the movements become stronger and more rational, a little illogical sometimes, but fundamentally more rational. And the other side fights back to control their power. It's exactly what you would expect them to do. But fundamentally, I think that they are very weak because the power really does reside with us. Look how often we've been able to push them back. Not every time, but often enough to prevent a mandatory swine flu vaccination program in the United States, often enough to force the FDA to drop dearly held draft guidelines that would have turned anything used to make you feel better into an untested drug. There examples being holy water and hot rocks in a massage, and we fought them to that. Your organization's Citizens for Health has done so on many occasions. So we are really quite a force to be reckoned with, but they're quite considerable, and they have more money than God because they get their friends to print it when they need it. So we have people, and I learned from you years ago, Jim, that there are two kinds of wealth in change. One is money, dollars, and the other is people. If you don't have dollars, you need people to affect the change that otherwise is bought with dollars.
I with that slightly. I say now it's either money or power, and if you don't have people, then you got to have money. So what we see is all these money bags running around because they can't get the people. So they're out there buying their way because they can't get support for what they really want to do.
Exactly. How very powerful and profound. Ralph, I know you have thoughts on this area. What are you responding to as we're talking about this in this last couple of minutes?
My thought is, folks, what you heard today is an exposition of the rights of humanity, and we have an opportunity coming in the next few months to solidify our position in order to defend your rights. We need your help to do so. We need your support. Please go to http:// Dr. Rima, that's DRRIMA, truth.com. We need your support. Without that, all of our theorizing about rights and about the history of freedom will prove to be just talking. Why, Jim, do we insist upon both talking and doing? Well, that's because we have not just the right to speak, but we have the right to associate. It's our freedom of expressive association which is being attacked by the FDA and the FCC. Not just our freedom of speech, but our freedom of speech and action. And that is really the gravamen of this issue. The sine qua non of compelled speech is truth. If the government can force us to express an opinion we don't hold, what can it force you to do, folks? That's my thought, Dr. Rima.
Absolutely. Well, we're coming to the end of this edition of the Dr. Rima Truth Reports here on the Micro Effect. By the way, the Micro Effect is a publicly supported station, and you really need to support it. Our guest, Jim Turner. Thank you, Jim, for being with us. Thank you, Ralph, my co-host.
Thank you for having me.
A pleasure.